And you have been one of the principal architects of the policy related to use of monitors, as you mentioned in your remarks. How does this new guidance fit with that? How are you thinking about the role of compliance programs in determinations about the use of monitors?
We did the monitor policy earlier in the year because I thought it was a little bit easier to get done. Ideally, we would have done these two in concert. I think they fit together well in the sense that the monitor policy is very broad guidance that tells prosecutors monitors can never be punitive. They've got to be done for the right reasons. You need to do an assessment of whether a monitor is appropriate, what the scope of that monitorship should be, the duration of that monitorship, given how invasive and expensive monitors can be. We want to make sure, and that monitor policy was intended to ensure that prosecutors, when they made recommendations to the leadership that a monitor should be imposed as part of a corporate resolution, that we did so for the right reasons. The document today is kind of what gets you there. The decision that you're making at the end, this document is meant to help frame, in part, that recommendation and that decision, because I don't believe in imposing monitors for any punitive reason. But in order to decide whether a monitor is appropriate, what the scope of that monitorship looks like, and what the duration of the monitorship should be as part of a corporate resolution, you need to make, I think, a thorough and well thought through and reasoned and fair assessment of the company's current compliance program. That, to me, is the ultimate question that needs to be, when you ask the question, do we need a monitor? The way you answer that question is, well, what does the compliance program that's currently in place at this company look like? Could the misconduct that occurred, could it have been prevented by by the corporate compliance program? Has it evolved over time, whereas maybe at the time of the infraction, the misconduct, the compliance program was not fulsome enough to catch it, but the company, in the course of us sitting down and talking through a resolution, they've made changes to their compliance program such that by the end, a monitorship isn't necessary. The framework that we've released today is what's going to allow prosecutors to get to that decision.
And was it also part of your thinking that when a monitor is imposed, the framework would be useful to them in offering guidance in their work with companies that they're monitoring?
The monitors themselves?
Broadly, it sounds like the three questions that you've posed in the new guidance are fairly broadly stated, and I assume will be helpful for monitors as they're thinking about how do they help companies improve.
I think so, because
practices.
When you look at the framework and the questions that we've posed around them, the answers kind of suggest themselves. And so as a monitor, when you get to the end of your monitorship, if you want to look back and look at how we viewed the compliance program that led to the monitor, and you look at the questions that we asked ourselves at the beginning, hopefully you'll be able to answer many of those questions in the opposite way at the end of the monitorship. I think that in addition to us wanting the monitors to be able to look at this, there's an element of transparency in this and it's a theme that runs through what we're doing in the criminal division right now and at the department more broadly, which is we want corporations to know how we think about cases. We want them to know how we think about resolutions. We want them to know how we think about compliance programs and how we analyze the effectiveness of compliance programs in the context of a corporate resolution, because we want them to have as much information as they can possibly have as rational actors to make good decisions. And we think that the right decision in corporate cases when you discover misconduct is to voluntarily bring it to the department, disclose it, cooperate, remediate. And when you have as much information as we can give you, we post declinations on our website now so companies can see when a corporation went through the process of getting investigated. These are public investigations. We wouldn't post anything that was non-public. But when it's become public that a company's under investigation and we decline against that company, we post the reasons for our declination on our website so that the world can see them. And it's in part so companies can make rational decisions about how to behave in the future, because they know if we behave this way, we're more likely to get this resolution, and if we behave this way, it's going to look more like that. That transparency also holds our prosecutors accountable, because it forces them, because they're going to sit across the table from sophisticated counsel, who are going to take the transparency and the information that we've provided, and they're going to advocate for their clients. My client looks more like this, therefore we deserve a declination. They don't look like that, therefore they don't deserve a DPA and a 3-year monitorship. And it puts the onus on our prosecutors to be very rigorous, and to be able to justify and defend and support the resolutions that they're recommending up the chain to the leadership. I'm sure not all of my prosecutors are happy about this amount of transparency because it makes your job a little bit harder from time to time, but I do think that it leads to fairer and more just corporate resolutions because of the consistency that it promotes.